Hello. Oh, hello, lovies. How are we? Today is Thursday, April 17th, 2025. Oh, don't touch the button. And we've got Jesus. Jesus is riding with us. Tiny baby Jesus in the new microphone stand. Stay there, my king. Literally, my king. Oh, find your home. Oh, okay, there he is. He will be with us tonight as we go through many, many emotion. Hoo-hoo! How are we, babes? Oh, I'm sorry. Hi, everyone. Hi, Laura. Thank you for joining. Um, who said Melanie Gore? Your hair looks so good. Oh, babe, this is for Jesus. Okay. What we're doing right now is the bigger the hair, the closer to God, if you will. Just saying. How has your week been, lovies? How are we? We finally got our jury impaneled in Commonwealth v. Karen Reed. We have 9 men and 9 women. Do I like it? No. I'm going to tell you the truth. I wanted all women and women in STEM. Okay, that's what I'm going to say moving forward in my life at any turn. Okay, is I'm going to say, you know what? I'm sorry right now. I can't discuss this. You're being a disrespectful teenage daughter, and I'm a woman in STEM. Okay, don't have time. Can't process the disrespect. So I wanted 18 women in STEM on this jury, but I'll take it. I'll take the 50%. You know what I'm saying? Yes. Love a Romy with cheese says 100% agrees. Oops. Gray space as a woman in STEM concurs. I appreciate this. So, babes, we have had literally a week, 2 weeks, really. It took 10 days to impanel this jury. It took 10 days for me to realize how to use this stand. It took almost one night of Mr. Nurse Kim saying, I'm filing for divorce. Okay. Because you don't know how to work technology. But we are here together. We are here for the love of what? Justice, truth, and to all the fugglers in Fuggler Nation. Okay? If you won a fuggler last week on Nurse Kim's live show, your fuggler is coming. I'm going to tell you, as a woman in STEM, I'm not paying $45 as UPS tried to get me per fuggler to ship to you. So guess who has the cheapest prices? Wouldn't have guessed this one. It's the United States Postal Parcel Service, which I went to twice this week. And apparently every grandmother in the Northeast, Southwest, and I think the Rocky Mountains is sending Easter baskets to their grandchildren. So, babes, I'm doing it tomorrow for you. I am going to also send you a receipt because you sent me your email, and I'm going to give you a tracking number. And that fuggler is going to be there with bells on, just like tiny Jesus. Okay? Now, let's get into it. Look at 2 potted plants. Kathy S. says United States Postal Service. She knew. Okay? Clearly a woman in STEM. Just saying. Oh, and just before we get going, babes, I did want to tell you that I found another clip on the World Wide Web, as I do, okay? Kind of like our don't be suspicious, right? We have another clip. And this clip really is going to embody every single time we clutch our pearls and clench our buttholes due to the Commonwealth of Massachusetts and specifically Hank Brennan. I want you to try it out. Tell me what you think, because this tickles my fancy when I hear it and or play it.
I know something's weird, and now I know it. That's why your whole jug is out. I understand. I thought this was happening. Y'all are running game.
Her jugs are just out because this is what they normally are doing.
Yuck, Jesse. What y'all are doing right now is gross.
Okay, it's gonna be our clip for when we're we're feeling Hank getting a little bit feisty, potentially showing his lockjaw. Okay. I haven't seen that much TMJ since Girls Gone Wild 2002. Know what I'm saying? Maybe you don't. But let's get into Mr. Alessi, starting us off strong 5 minutes in. Did I hit the button? Okay, sorry. This is going to be like an up, down for a couple of streams so that I don't hit the button. And I am on the moon on the cell phone, so no one will find me. All right. To the clips, my loves. Let's rock and roll, babes.
The motion in the discussion with regard to Dr. Crosby. So in conclusion, Your Honor, we require determination until the court reads the report of Lieutenant Wynn.
Right.
Thank you, Your Honor.
Okay. All right. So there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific.
Oh, Beverly. Judge Cannone, this was the moment yesterday in which I felt a spark of joy, if you will, just creep up my spine, right? Started from my sacrum, okay? Worked all the way up to my cervical spine, and I said, bitch, what are we doing right now? She was ready. I don't know how you're going to get here, Hank. And let's see if he does.
Dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study.
Well, thanks, Captain Dipshit. We really appreciate you letting us know inclusion and exclusion are two different things. Woo! Glad we woke up today.
Well respected. I've read it many times. And that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring.
No, except the doggies, all right? Except our canines, Hank, right? They're not humans. Typically, they don't get their orthodontia done, right? They're lucky if they get those little beautiful cleanings and some green bones. And you know, you're just looking for all the dental hygiene you can until your small dog's mouth starts to smell, okay? Doesn't matter if you've taken him, gotten those teeth brushed. They're going to end up with four teeth left by the time they're 7. It's a known fact. I'm a woman in STEM.
The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able
Right.
to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds show to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's
Okay, just going to stop Hank right there and let's do a little bit of a reminder, babes. We know that Officer John O'Keefe was, was found on the lawn of 34 Fairview on January 29th, 2022. Okay, fact one. Fact two is that Chloe, a German Shepherd who played the role of, quote, family dog for the Alberts for 7 years, was then spontaneously rehomed after images of Officer John O'Keefe's right forearm were provided to open court in 2023. Okay. If Hank went to Vermont, oh Jesus, we're doing a word problem right now. We are doing SAT prep. If Hank Brennan went to a farm in Vermont and met Ben and Jerry, and Ben and Jerry housed who? Chloe, okay? And also had 4 chickens, 3 ducks, and a partridge in a pear tree. Would Chloe's mouth be the same in December or whatever of 2024 as it was in January of 2022? Okay? And how long would it take you a train to go at 46 miles per hour to get to Canton? I don't friggin' know. But the answer is, as a woman in STEM, Chloe's mouth could 100% have different spacing at the end of 2024 than it did at the beginning of 2022. I rest my case, Your Honor.
exclusion, not inclusion.
It's an uphill battle for
She
you, I'll
hated
tell you
that.
that. I'll hear from Mr. Wilson.
Ooh, keep running up that road. Keep running up that hill, Hank.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. Ooh. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we
love a good, babes, I am physically plugged in right now via the Ethernet. If the government of the United States of America and or Hank Brennan is into my computer, there will be hell to pay. Okay? Okay, am I bugged? I don't know. Because how did I just have a glitch when I'm plugged in? I am not Wi-Fi based. I am a physical jack in a wall. I feel like that's the correct term as a woman in STEM.
What Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you.
Yes.
Did you want to reply?
I would suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there being discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So
Just a reminder, babes, in the beginning of this hearing, what did I feel? A lot, okay? We had the tingles up our spine, a spidey sense, if you will. But I believed that potentially Beverly Cannone had made her way down to the Cape. For what? I don't know. Maybe to just check the pipes, do something at the Cape House, right? And she was knee deep in clams, and you could see a difference. You could feel a difference. And I think it brought joy to her. And in turn, we received a softer side of Judge Cannone for a minute. Oh,
all right. Thank you. The substitute.
yes, we have to get to minute 15, babes.
Hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay.
Can I make a note?
Yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation of text messages, but I think an independent reader is fairer, more objective, and we'd like to.
Well, well, well. There was no opposition from the defense for the extrajudicial statements of Karen Reed to be introduced into 2.0. Bitch, that was every single troll's like calling card. They told us to, I don't know, even get in the back, bitch. That's what they said to us. They told us horrible things. And they said that she is going to absolutely get crushed by her extrajudicial statements. Well, no one opposed it. Okay, Hank? No one even fought you. They stood up and they said, okay, do it. But then Hank pulls this little fast one and says, yeah, we also want to get a reader. Well, babes, I just need to let you know, Jimmy and I will be auditioning for the part in Commonwealth v. Karen Reed 2.0 on Saturday. At what time? We're not sure. When the spirit moves Jimmy, if he's awake, okay? If Auntie Deb can awake from his slumber and join me, we will be reading for the female and male parts, potentially as ourselves, maybe as the opposite sex. Who are you to know? You won't until you join us. We're going to send that submission directly to Norfolk Superior Court, to Alan Jackson, and to Hank Brennan's petty paralegal in an ill-fitting pencil skirt. Will we get the part? We don't know. Stay tuned.
Have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right. How are you going to find this person?
But we could have somebody playing close from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay.
May I have a moment, Your Honor?
Yes.
Oh, is this me? Are we blank spacing right now? What is happening? I can see, but I can't hear. Are they muted or am I muted? Oh. Oh, Lord. Oh, just kidding. He comes back. We're okay. All right. No Maydays here, babes.
Your Honor, thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides.
Garino.
That was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts of the trial when they become relevant. So it's not sufficient to simply have a state police officer.
Oh my gosh, Shaggy, was it me? Should we do a read off? Should we invite Melanie and Will to our house so that they can also try a part? Don't even. If we make this a thing, babes. Who's getting the part? We'll have to see. Poll at the end.
Who was not a witness to those text messages to come in and read them continuously through the trial. Mr. Guarino is an independent witness in this case. To bring him back regularly as a police officer, I think is creates the wrong impression. I think objectively we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Guarino is the one who found, he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate.
And we know I am a horse girl, not a theater girl. Jimmy can't say the same.
I don't know who these individuals would be. And the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reader?
Yes, we do, Judge Cannone, right here. Okay. Nurse Kimmy and Auntie Jimmy. All right. We are here for you as needed. No inflection, no theater, just straight shooting. You know this.
Reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want.
Yep, that felt homophobic, and I'm going to hold that against you, Hank. Grab your pencils, you prick.
I think that's inappropriate. It's not going to be misread.
Me too.
And it's not going to be misread. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. It's I understood
Perhaps a nurse from the Merrimack Valley. Yes, Beverly, continue.
it to be to take out all infliction and complete.
Yeah, well, infliction would be pain and suffering, and not inflection, which is the dog crossed the road. Is that a question or a statement? I don't know. As a woman in STEM, I would tell you we are correct no matter what, and we should be given more opportunity.
Completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and be incredibly objectionable. And then once it's done, it's done.
I will consider it.
There'll be no inflection. That would be inappropriate.
Oh,
Thank you.
and then he chimes in. If you guys heard that, Hank Brennan chimes in and goes, "There'll be no inflection." And he moved his glasses. I didn't see it, but I felt it. You know what I mean?
All right. Defendant's motion for specific discovery, paper 638, Jimmy.
Paper 638.
All right. Who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related.
Thank you so much, Cheryl, with an asset member for 4 months consensually at Nurse Kim's house. I must let you go, okay? Like a fish, I have to give you back to the North Atlantic Ocean and let you be free. You don't need to be here for more than 30 days consensually. You know what I'm saying? I appreciate all of you that do that. And in the name of tiny baby Jesus, we thank you, Cheryl. Okay. Also, look at Mr. Yannetti. Does he look like a bowl of spaghetti? 100%. Are we obsessed with him? Yes. Does he get into some sort of camaraderie and or negotiation that he did with Hank Brennan? Yeah. Yeah, you did. Okay. Do we care about it? No. So let's get to the next part. It's not big doings. They were just changing language, babes. So now we're going to go to 53 minutes because this is the moment you've all been waiting for. We're going to start it a little early because we know that I like a little bit of build up. You know what I'm saying? With Falcon. Yeah. Hank is letting this happen. He doesn't know, but we know.
But that same day, the defense was provided all the additional materials to ARCA, including Dr. Welch's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh, I didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as officially.
Well, this is what I want to hear. Oh, is she on? Okay. Oh, I'm sorry. Where are the ducking socks? Just tell me that Will said he is down if Melanie is down. I'm sending out a text, babe. Soon as we get off this stream, we're going to know about it. Okay. Can't do it. I'm on the moon right now and I've got too many things happening on this screen. However, we're going to have an answer for tomorrow. And if we're doing a Saturday read off, get your lives together. Clear your calendar. We're going to need 2 hours. I love your faces. Tell me more, AJ.
We possibly can, but we can only do so much, given the fact that we were only providing.
Also, I'm competitive. I'm not taking this one down, okay? I maybe have the nickname in my family, Competitive Kim. Oops, you heard it here first.
Access to hire ARCA on March 26th.
All right, Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern.
We're about to see Poindexter get big mad. Are you ready? Let's go.
In fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARC from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds it's not in their possession of control, that's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it.
Wow.
I believe there will be information that ARCA has if you order them to bring in all.
Call the wambulance, okay? Call the wambulance, Hank. Hank Francis first of your name. It's rude. You sound like a toddler who got his blocks knocked down. You're knocking down my blocks. Well, you know what? You're the home team, asshole. And your blocks suck. We got new blocks, bitch. Just saying.
All of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that.
We can
the ARCA
live with
witnesses
that.
provide a report does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until.
I'm sorry, sir. Did you just hit us with a hard P? I have prepared for that. Oh, Hank, calm the fuck down. Prepared.
The last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with.
Babe, do you know what the eve is? Do you know what that means? The eve would be like tonight is Good Friday Eve, babe. Okay, let's say some prayers. Get your baby Jesus. We have him. Awaiting, just sitting in a boom. Where was Jesus last night? Nurse Kim's house, sitting in a boom. Leave it alone. You, good sir, calm the fuck down. We have several days. And just because you allege that the defense did not give you every piece of information that they most certainly have given you and gave you since the first time you got your honky hanky ass up to that podium and were talking shit during the, as we will refer to it from here and now on, as the Judge Bev breakdown heard around the world, pal. Okay? Was the sugar low? We still don't know. But what we do know is that you got up there and made a material misrepresentation to the court, then walked it back like a tiny little bitch, and still have problems with it today when we say, yeah, we turned over, aka the defense, turned over all the information that they have in totality. That's a hard T for your hard P. Okay. And that sounds weird. So we're going to move forward and pretend I didn't say it. But yeah, shut up, Hank, and stop it.
New opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructionists they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welch's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a TUI request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate.
What does a pussy say? Meow. Okay, what's going on here? Meow. Calm down, Hank.
Anyway, we have no ability for our experts to then go through and conduct more testing. This is the preparing for the, they had that obligation. After we've already told the jury our theory and our science and not have a chance to rebut it or consider it, I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case in scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7th, 2025. Your Honor, I ask you to allow our...
Excuse me, lovies. Is your internet on? Do you see me? I mean, not me. It's a tiny picture of me. But is this going at an appropriate speed? Or are the gods against us? Please tell me. At your convenience.
To testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025.
Oh.
We received a report, I think it was January 31st. 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a two-week request. We asked for a two-week permission, or asked permission to engage them through a two-week request.
Yeah.
That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day, provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judge Welcher's testimony or his reports, the last iteration of which we got on March 24th.
Oh.
So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander.
And there's nothing better to me, babes, than a goose and a gander. I also want to say, boo-boo babies, his suits are always perfect. Babe, you read my mind. That man looks like a tailored god, okay? I don't want to make Will feel bad about himself, aka the glarer. But allegedly, as lore would have it, Janet Reed once saw him with a jacket that was far too long for his hands, and it probably drove her crazy. And then she gets to look at this man, right? So this changed Will fundamentally. Will he try to bring his A game to the read-off? I think so. Continue.
Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judge Welcher's opinions and conclusions with rebuttal opinions and conclusions if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody's at a disadvantage in this trial. We're simply trying to meet our obligations
101-29. Jimmy.
as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted, and we're moving forward as expeditiously as we possibly can.
Oh.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judge Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided his CV in November, and then we provided on our discovery deadlines, January 31st, 2025.
Yeah.
And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines.
Yeah, thanks, Hank. Thanks, babe. Okay. Thank you very, very much. You're getting so flustered, sir, that you walked away from the podium. I just wanted to say, couldn't be Adam Lally. Oh, would never be Adam Lally behaving in that manner, you little fresh pants. But let's remind us, babes, that when member Hank Brennan got up and said that he had sent his TUI request to the feds when he made his material misrepresentation to the court in February of 2025. He mentioned that on, I believe it was February 7th, correct me if I'm wrong, but around about February 7th, the defense and the prosecution, aka the Commonwealth, were finally given the go-ahead for engaging ARCA. So that was less than 2 months ago-ish. And the CV of Mr. Welcher is about as useful as toilet paper in your uncle's bungalow. Okay? I know your uncle has a bungalow somewhere in Key West, allegedly. He fled there after a DWI in 2015. Is your uncle Whitey Bulger? Things I would like to know as a woman in STEM, Hank.
The changes to Mr. Welch's report have been the complaints, understandably, about what they believe was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
Bullshit.
According to Mr. Alessi, who is much more facile with the facts of what's in Judge Welch's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judge Welcher.
Yes.
The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier.
Tara, I do not want you to feel left out at all. So you can be a woman that likes STEM, okay? Or likes stems, or has nice stems, AKA your legs. I don't know. All right. Must be jelly because jam don't shake like that. That's what I heard.
So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right. Thank you. I think the only thing left the motion to sequester Aiden Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes.
Oh, we don't care about that. We're going to listen to, it's an OnlyFans sighting. Let's talk. Okay, babes. So now this is the main event. Okay. There's a lot of shit talking online. A lot of people saying they know what they know. Okay. And you're not going to tell them shit. And that by Aiden pleading the fifth because he had nothing to do and did not know any of the players, including Karen Reed, the defense team, God rest his soul, Officer John O'Keefe. He didn't know any witnesses. He knew nothing. He probably had never gone to Canton in January 29th of 2022, right? And yet this dirty fucking scuzzbucket named Hank Brennan is attempting to bring in Aiden and Karen in some sort of got ya moment when they already have an open and ongoing legal litigation. It is completely and utterly a false representation to say that there is any correlation between a relationship or, a source and a journalist from 2023 in origin to all of a sudden correlating that back to the death and the events that led up to the death of Officer John O'Keefe. Shame on the Commonwealth. Shame on Hank Brennan. And I just have something right in my pocket for you. On your mark, get set. There it is, Hank. That one's for you. On the eve of Good Friday, because I wouldn't be able to do this tomorrow. Thank you. Thank you, OnlyFan. Put us to bed. Cure your insomnia. Watch this moment back in time. Okay, now let's get to Brennan. Oh, everyone goes to recess. Everyone goes to recess like small children because Hank Brennan's a bitch. In my opinion. Let's go.
All right. Were you as well, Ms. Little?
Yes, we were able to see the video. We have no objection.
For a
And I
motions
did-
hearing. Today's court appearance comes after a full jury was seated for her second trial yesterday, which means opening statements begin next week. It looks like today's hearing is underway. Let's listen to
Hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay.
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
Okay.
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
Okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay. Can we address, is it something you need for your opening?
It's not.
First of all, AJ, love your face. Let Liza finish it up. She knows exactly what she's going to say. But speaking of openings, I am verklempt. I am ready. I am razzled. I am dazzled. I have two different versions in my brain that I believe the defense will go with. One of two, a safe route and a balls to the wall route. Just saying. So as it relates to Kevin Albert, I say that if you are the brother of a homeowner at 34 Fairview, where Officer John O'Keefe was found on a lawn, tragically either passing away or expired on January 29th, 2022, I'm going to need you to absolutely get ready to rumble. Okay. What we're going to do is we're going to do, licensed gun owners and holders. We're going to do a little game of roulette and see whose mailbox is my gun in. Okay. We're going to do a little game of DUI or do we die? Okay. Which was exactly what Proctor and Kevin Albert were playing when they were handling a cold case together after this investigation had been completed. You are all a bunch of dirty, dirty dogs if you don't think that we know your connections run deeper than whatever bullshit we were able to see on your text messages because it fell within the date ranges. Okay? Had you gone back further, gosh only knows what would have shown for a connection between Michael Proctor, in my opinion, and Kevin Albert and potentially other members.
Okay. All right. So yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out. All right.
Thank you.
Okay. So now is the only thing left the motion that Mr. Bradle's here for?
Mr. Bradle.
As far as I know.
Okay.
Oh, I'm sorry. I'm going to need us all to take a moment because we saw that softer side of Beverly, and also her hair is on point today. Kawinky dink? I think not. Let's sing it together, an old 1990s cartoon. A skidamarinky dinky dink, skidamarinky doo. I love Bradle too, but she loves him in the morning and in the afternoon. I'll keep my day job. But look at this. Did you go see Teresa? Did you get your hair done by Teresa in Newton? Did you lick your lips? Beverly. You got a thing for the Bradle. Something about Bradle. I hear ya.
Right. Morning, Mr.
Oh, Beverly.
Bradle.
Good morning.
Okay. So, Jim, you have that. All right.
Listen to me. Where are you? Oh, I can't even see you. Carly, did you just say, is that a grin too? I haven't seen Beverly Cannone grin. A chagrin? A grin. For reals. IRL. A wink? And a smile? I know it. Listen, I'm a lady too. A woman in STEM. I know what I see. I see what I know. We're stopping the camera. We can't miss this. I'm going to leave my effing body. Ooh, babes, just hold on tight. I'm so sorry. I've turned my camera off because whoop, the internet hates me still. But we're going to wait until I come back. You just tell me in the chat, say, Kim, we can hear you clearly. And I'm going to try to play this because I refuse to skip a beat on Tim Bradle. Do, 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 do. All right, it appears to be good. Per the government, per like the StreamYard is saying it's okay. I'm gonna risk it for the biscuit. Woo, Melanie Gore, we hear you. Woohoo!
I have one, Jim. Thanks. All right, I will hear you. Let me just ask Commonwealth, you're moving to, sorry, you stay right there, Mr. Bradle. Mr. Brennan, you're asking for sequestration on all the witnesses.
What was that? Was that a giggle? Stay right there, Mr. Bradle. I feel like she's clutching her pearls. She would have been fanning herself, ladies. Had she had a decorative fan, we would have felt that breeze from here. Know what I'm saying? She should have been breezing. I hope she has a fan under that bench, you know? That's fresh. I apologize. I'll pray.
Other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aidan Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses.
No.
The other is rebuttal. If the defense calls the defendant to the stand, then it is a strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Okay. All right. Now I'll hear you, Mr. Bradle.
All right. Thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
Can I just ask if he were to call?
Let's point him out, babes. Where is he? Let's play Where's Waldo with TB right now. We see him. We're going to point to him. There he is. The turtle, the boy, is present. And then we have Meredith, and then we have Kelly, and then we have Esty, and then we have Nathan, and then we have Mr. Reed. I could do a whole calamity. I could do an entire recite everyone that I see. But this is what I really see. That is a man with a beautiful part. Okay? That's no plugs. That's no rugs. That's au natural. His father was a playboy. His grandfather was a playboy. And his great-great-grandfather before him was also a full head of hair. Thick. Salt and pepper. Right? Beverly couldn't stand a chance, guys. What? She had no power. Look at him. The man is a work of art. Continue, Mr. Bradle.
Your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness
Okay,
intimidation.
so just focus back on.
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor,
Oh, Giggles. We'll call us Giggles McGee right now. She clearly, Judge Cannone said, I'll hear from you on this, Mr. Brennan. And Mr. Bradle goes into it. Now, if this was anyone on the defense team, there would be hell to pay. Not for Tim Bradle. Not for that salt and pepper king. Now for that silver fox, if you will, thick. That's what we're going to refer to it now. Okay? Thick 'em.
Under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was, I'll hear you, Mr. Brennan. And you
Oh, I'm sorry.
But that's okay. I don't want to hear about the witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney, will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
I'm sorry. Was that 2 smiles in less than 5 minutes from Judge Beverly Cannone, who is typically full of baloney, not salami? Okay. Look at her lean back in this chair. 411, all 411 of that Polly Pocket was ready. She was ready for what was next. Bitch. She just licked her lips.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, I would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
Yeah, it's ongoing. Alleged victims, but you're all right. All right, Hank.
Okay.
As a predicate, he would need to assert his fifth.
Do you need that to be done formally, or do
Yes.
you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
Would reject that invitation if he wants to.
Forgive me, tiny baby Jesus. Do the right thing here. Get Kim's shit together. Listen to me. We'd reject that, okay? Because you got to give it to Tim Bradel. You got to give it to a man with that thick kind of hair. You know what I'm saying? He was like, I'm going to assert it for Aiden. And what happened was that Hank said, thanks, but no thanks, okay? He said, I'm going to need you to walk away slowly. He felt like he was going to show his aggressive bear side, but no one thinks you're a bear, Hank. You're a weasel. A weasel is not a bear. Okay? And Papa Bear Bradel is going to come and show you, little cub. Okay? You're getting your species mixed up. Thanks.
To assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel? Or no? Do you want to talk with your client? And
7 minutes.
sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody's there. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
Babes, when I tell you, I have never wanted Karen to have another attorney more than I've ever wanted Mr. Betterow, right? Mark Betterow, our guy. That's who I believed would be the actual workhorse that I know he is. Him in conjunction with the rest of the defense team was the dream team, right? We still have the Reed team, but you want to put in someone that would give a little flair, who would potentially put Beverly in a case of the happies, give her the giggles. Listen, that's half the damn battle. I want Bev giggling. I want her loose as a goose. I want her to feel the energies. Okay? I want her healing with crystals and shit. You know? I want her to tap into the energy of her ancestors, the witches from Salem in 1692. Let's see if she gets there. 10 minutes for Bradel. kind of a jam. Okay, let's find, where am I going now? 158. Sorry, babes, bear with me. We're coming back. Damn, that's a bop. Is it weird that I'm getting so old that when I go to the grocery store now and or any TJ Maxx, I am full blown in a karaoke like bar, okay? Can't tell me shit. I've got an Essentia water and 30 minutes to spare. There's things that only a woman's mind can, uncover in that time in a store. Take me back. Take me all the way back to 1999.
Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right, thank you.
But I just want to remind us all, babes, okay? Just go back in the hands of time with me and understand how underhanded this is. Again, we've already touched on it and I don't need to go into it again, but like for real, Hank, for reals, the fact that you are so underhanded, in my opinion, right? And that you're such a fucking sleazeball weasel motherfucker, that is upsetting to me because that little powder puff, that little donut of unknown origin sitting right next to you, okay? With just a little tiny munchkin hole right on his head, right there, okay? That's Adam Lally. And he's not a prick by nature. He went a little bit far in 1.0, in my opinion, because he didn't need to bring the Aruba incident in. But he wasn't effing with Karen regarding her Boston Magazine interview or the 2020 that had come out, right? Then we had, after trial, we have Dateline. Then we had Vanity Fair. Then we had the ID and then another Vanity Fair. There's been a lot. But if your case is strong, and this is, remember, babes, this is the retrial of the death and the murder, allegedly, which still hasn't been ruled a homicide, but, fuck my life. This is Officer John O'Keefe's life. And when Hank Brennan makes a mockery of it and talks all the shit about a potential, journalist / defendant relationship,
Suggest that
it's rude.
the court could take you.
It's rude, in my opinion. And it cheapens Officer John O'Keefe's memory. It's disrespectful to his family. And it's plain dirty. Everybody sees you for what you are, Hank. You shitbag. Continue. Sorry, Mr. Bradle.
Just notice of the 16 indictments against him.
So the Commonwealth concedes, I believe there's a valid Fifth Amendment right.
So yes, you just allow me to make the representation on behalf of Mr. Carney that I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Mr. Kearney to for his fifth.
Oh, I
Sure.
thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradle.
Thank
And all recording devices are off.
Thank
you.
FTR goes to sealed, Tori and Chrissy.
So then she turns the volume off. No problem. Look at Aiden. He goes and he's bopping, right? Team's doing a team meeting. Mr. Alessi, just back and forth. He is a shortstop. Doesn't he give shortstop energy? Obsessed, right? And so they go up, and this wasn't done in open court like Hank Brennan wanted it. We see all of the court jesters. No, all of the court officers. Sorry. Had to break it down for a second. All the court officers had got into the room. Why? because this was interesting. I think they come there just because it's interesting, but a lot of other lawyers have said that it would make them extremely uncomfortable if there was that many court officers, not jesters, that were standing about, because it would make you think like, is there like anthrax in the building? I don't know if you can say that on the World Wide Web. But seriously, it's a little nerve-wracking, right? Break it down, babe. Oh my God. WBZ. You got the hits.
Colloquy with Mr. Carney, with Ms. Lord present,
Colloquy.
obviously. I find the Commonwealth concedes that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege. And I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the.
You didn't have a, okay. Okay, everybody, I'm sorry. Puke Brigade, are we here? Yeah, I'm glad that you accept those findings. They were final. You frigga.
Two minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may,
Oh,
just for the record, maintain this.
Oh, somebody make me a shirt, make me a t-shirt that has this face of Judge Beverly Cannone just feeling things that she hasn't since 1982. Is it me? Is it you? Is it Jesus? Is it little baby Jesus? What is happening? I like it. Who am I shitting? I'm into it. Get it, Bev? You know, she's trying to. Tell me more, tell me more.
Same objection I had at the last trial. Don't need to make any further commentary on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right. So we're all set until Tuesday, I believe. I'll get orders out. Oh, stipulations were just given to me. I have not had a chance to read them. All right.
There's a supply closet with their name on it. And I'm just going to say this one time, and I will deny it if you say I said it. But Mr. Bradel, maybe you need to get some, maybe you need to go get some paper. Maybe you need to go get a stapler. Maybe you need to get some tape. And you know who could help you find it in the closet? You know, Judge Cannone.
Looks like you all made some progress.
Oh.
In a way where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy.
And it is something.
Yeah, and the research is Nurse Kim. It's Nurse Kim. It's Auntie Deb. It's Will Vaglair or Attorney Melanie Little. Your choice. Okay? You pick. I want the Commonwealth, Judge Cannone, and Alan Jackson to all be on the same page. You pick. But it's one of us. Okay? That's it. We're the only ones who have applied. And we're sending in the tape Monday. We want an answer by Tuesday.
Thing that we've done.
Right. Understood. I would like to see I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on this read, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants brief, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All rise for the court, please.
Oh, all rise for the court, please. So listen, babes. I wanted to let you know that we got a couple of motions back, or not motions back, rather, orders back from Judge Cannone. And one of them made me feel like this. I'd like you to please watch this tiny clip from a television series called Veep and enjoy.
Get off the plane.
What?
Get off the plane.
Ma'am, we're taxiing.
I don't give a shit. Get the fuck off my plane. Yeah, get the fuck off of my plane. I cannot believe that you put that out on Tumblr.
No Tumblr.
Okay. Stop the engine!
That was me. That was me. Okay. And it was when I saw this. Let me find it. It lives in the media. It's this one. Oh, and you know I can't see it. Okay. This is the motion to exclude. You can see it. I can't because it's small. But at the bottom, pull it close to your face, babes. It has the following names included: Julie Nagel, Chris Albert, Colin Albert. Oh, baby Jesus, take me away. Michael Proctor, Elizabeth Proctor, Jennifer McCabe, Matthew McCabe, Yuri Buchanan, and the minors. Okay. And this was allowed, ordered, and demanded by Judge Beverly Cannone. Well, riddle me this. Why is it, babes, that I remember things that apparently Judge Cannone doesn't? Because I had a small, tiny freak out last year in May of 2024, because I said, wait, that's not fair, because Yuri and Michael Proctor are public officials. They are what? They are cops. So they don't have the same exact protections. Let's remove this. They don't have the same protections. Oh, where am I? Oh, you son of a fuck. What? Am I? No. Poor choices. There we go. They don't have the same rights afforded to them as regular civilians, like even Elizabeth Proctor would. And if Yuri was married, his wife would. Am I on? Yeah. Okay. So last year, Judge Cannone said the same spiel. And she was like, you're not allowed when these people are present. But then I remembered motion 356, because that's what I do. Women in STEM. Just saying. And this little memorandum came to be on May 14th of 2024. And she had ordered on day 10, which I don't know what day that was on a calendar, but before this. And she said all of the names I just read were to be excluded, and that Aiden could not be present. Well, this little memorandum says that Turtle Boy should be allowed. She changed her mind. She's revised her thinking. And this wasn't on her own accord. You know damn right well she was told by someone, okay? Who? I don't know. A boss, a friend, a paralegal. I don't know who told her. Teresa. Maybe she spoke to a crab down the Cape. But she changed her mind and said that the police officers, which I still can't read this. I am blind as a bat. But it says that there is no, that the officer, right, has no fear of Aiden Carney. There is no reasonable fear while he's on duty and giving testimony in a trial. So ordered that he may be present while Yuri and while Proctor testified. So she didn't even check her own orders from 1.0. Beverly. And for this to be a client of your boy, this isn't going to make Tim happy. Okay? This isn't going to get Tim to make a razor sharp part for you. And that was a part on his hair. Okay? Do you want to find a connection or tear you apart We don't know, Bev. But there's no reason that Aiden shouldn't be present for Buchanan and for Proctor. Even though he is a civilian now, he is testifying to what? Unless he maybe asserted his Fifth Amendment, there would be no reason for Aiden not to be present. Boom. Tick, tick, boom. All right, sorry, babes. Yep, here it is. Interesting. Thank you, Ashley. Peppermint PJ, she knows what's up. And absolutely, Carly, she didn't remember. But here's the thing. Why the fuck do I? Does that say something about me? Is it a woman in STEM brain? I don't know. But I am going to say this. I immediately knew as soon as I saw the new order, right? I go, well, that's funked because she had to change her mind last year. And then I go back, I turn back the hands of time. I start writing in the little search bar on Twitter. And the Twitter tells me, here you go, Kim. That's what you're looking for. The reversal. The change in opinion. Which came kind of out of left field there, Beverly. But you knew damn right well, for the record and for the law and the way that it works in the Commonwealth, police officers they're not afforded, unfortunately, they are public officials. So we are allowed to criticize all public officials to a complete different extent than you would be able to a regular schmegular human. So, for example, por ejemplo, if you will, Lizzie Proctor in her kitten heel, no fuck with. Michael Proctor, drunk driving on the Cape, fuck with. Legally. Just my opinion. Oh, are you shitting me? Tracy, get out of town. Gifting 20 non-consensual Nurse Kim memberships on a Thursday night at 10:19. I'm going to do some kind of spiritual cleanse regarding this. I do want to say to anyone who receives one of these 20 gifted, and they are gifted, special, if you will, I don't know. Poke around back there. See if you like it. It is unhinged. You did not ask for this, and I apologize in advance. I appreciate you, Tracy. Let's go to Spacey. All right, so that I just blacked out over, and now I forgot my train of thought. But thank you, Tracy. So that was the end. So Mr. Bradle, let's just listen to what he's... Oh, I can't listen to it anymore. I took it away. Oh, no, she said, we'll see you. Okay, we're done with that. We have this, okay, and now we move to the next one. This was the other issue that I wanted to go over with you guys, and this was the ARCA, and I can't see it. What am I doing? I can't even see it, so I'm going to have to... Oh, can I do it this way? Oh, God, help us all. Oh, can I make it bigger here? No. I always find myself just unable to read. Okay, I'm going to find it, though. Don't worry, babes. Just bear with me. It's the ARCA one. I'm going to look it up. I'm pulling it up on the World Wide Web. And we're going to read it together because it doesn't say what the government or what the Commonwealth wants you to think that it says. And everyone is saying, oh. And it's like, oh, it's not that big deal. Not that big of a deal. Everyone just, eat a fucking salad. You're hangry. Get some ranch, bitch. You're going to be fine. Oh, Okay. So I'm going to put it in here. Karen Reed. Okay. Karen Freed to be. Stop. Okay. All right. So here it is. Is this it? Yes. The Commonwealth. You can read it. I'm doing this. The Commonwealth moves pursuant to Trial Court Rule 8, Uniform Rules of Impoundment Procedure, that a letter from the United States Attorney's Office in response to a, quote, TUI request that outlines the permissible scope of the ARCA witnesses' testimony be filed under seal and impounded. Not weird. Normal. Okay. There was a federal investigation. We are smart. We know this. So then it says the exhibit contains references to the confidential federal documents, which are restricted by a federal protective order. The protective order does permit disclosure to the Norfolk Superior Court for use in this criminal proceeding, provided that the court authorizes the sealing and impounding of the records. Oh. Okay. So what did she say? Allowed. Judge Cannone allowed the records to be sealed and impounded. I don't know why everyone that is a Commonwealth stan felt this was such a win, and they were like, this is it. ARCA is not coming. I will bet you anything that ARCA is coming in. And if you want to bet me, you are the dumbest of dumb. Okay. You are Las Vegas's dream, wet dream. Okay. If you would take that bet and think that this, by reading the header that says the Commonwealth's motion to impound exhibit in support of Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or exclude their testimonies, she didn't exclude anything. She's asked, it's only the part of impounding. So I'd like you to go impound sand. Okay. Love you. Okay. We pray for all. Tiny Jesus is among us. All right. So what else was there to say, babes? Talk to me. Tell me. Let's talk all the shit. That's what I wanted to go over with you. We know that we have, again, 9 men, 9 women. Would have liked a little better. I would have liked it to be at least 60-40. Well, Jesus, can we? Thank you. Jesus has stayed still. But I think that we're going to be in a good spot. I truly do. Okay. Oh, let me find you. I'm sorry, babes. Oh, where? Oh, she's gone. She's lost. Where does this live? Okay. Bye-bye. I love you. Oh, why am I this way? Is that better? Look at her. Look at her. She's got that big hair. Don't care. Bow, bow, bow. And a Chloe in a pear tree. Okay. Let us talk. Oh, TB's new article. Oh, Carly, I can't do this. I would do it, babe. I can't get there. What does it say? Tell me everything. I can't find my way and then find a login, and then it'll be a nightmare. But tell me, give me the deets. Oh, what does impound mean? Kathy Beans, of course, Lovey. Impound just means that the public, us, we can't know about it. It can only be known to the defense and the prosecution and the court. So it is not going to be public information for us. Is she a non-consensual intern of David Yannetti? Has it paid off? Some may say. Oh, go on my phone. Okay, I could go on the phone. Stay with me. And let's see if I could. Oh, look at this. D Mart says, Nurse Kim, can you look on your phone for the TB article? Yes, I can. Let's do that together, and then we're going to tuck and roll. But let me see. No. Oh, actually, wait a minute. Hold on. Stay right there. Don't screw it up. Do not, whatever you do, Kim, I'm removing this. Am I removing this? Stop sharing. We've stopped. Now, I'm going to get rid of this. Can you see me? Okay. Guys, we're doing this. We're magic. We are magic. I'm going to try to find this. Did Aiden put it on his Twitter so that I could click it there or no? Oh, I don't know. I don't know what's happened now. There is, can you, woohoo. Okay, focus. I'm going to go to the search bar and I'm going to say Dr. Turtle Boy. Dr. Turtle. Don't be a squirtle. Oh, I see it. Oh, lovies. We've got some shit. Holy crap. This already has 4 hours ago, disgraced former Dedham police officer Ty Donahue, who was fired after flipping his car during a DUI, had a personal relationship with a Karen Reed not guilty juror that got ugly the day before closing statements. He is family of a Dedham man named Ron Hathaway, who used an anonymous Twitter account to spew McAlbert propaganda for months. Hathaway is a cousin. Wait a minute. Is it Ken Hathaway? Oh, Ron Hathaway. Okay, sorry. Hathaway is a cousin of Jen McCabe and her 3 sisters. Coincidentally, the day after his personal relationship with the juror blew up over some major lies he had been telling, the juror was reported by John Fanning for something she allegedly said at a bar more than a month prior. This is the real story behind the jury tampering in which the most obvious not guilty voter was targeted and prevented from deliberating. Oh, bombs. Okay. Hold, please. I have to repost this for the Lord. We're reposting. Then we're clicking the TB Daily News. And am I allowed? Okay. I'm going to get in here. Okay. Can you see me? All right. Can I get rid of this? I'm going to do this. I'm going to get rid of that. Okay. Here it is. I'm going to try to get in. Okay. Can I share this? Oh my gosh, guys, I'm wicked sorry. Bear with me. Let's try to present it. Will she do it? Present. Share a screen. Can share it. Guys, if we do 2 different things in one night, just going to say sky is the limit if we're able to pull this one off. Split screen. God damn, I need another screen somewhere. Okay, we're doing it. Oh, can't tell me shit. Can't tell me shit on the eve of Good Friday in 2025. Let's thank TB, Small Jesus, and Tim Bradle's hair. Okay. En el nombre del Padre, el Hijo y Espíritu Santo. Okay. We're going. Here it is, babes. Okay, so this is it. This is the guy. This is the top paragraph that I read. The Ty Donahue is likely source of the lies told to John Fanning. Trooper Fanning. Okay. So now we're going to go here. On the final day of Karen Reed's first murder trial, a female juror who had been making faces throughout the trial, indicating that she was disgusted with the Commonwealth, was brought in to speak with Judge Cannone. As she walked by the menacing eyes of Brian and Colin, oh my gosh, Colin Albert, she seemed confused and shook as Auntie Bev grilled her from the sidebar. This juror, known as Juror A, had previously reported another juror to the court for making negative comments about Karen Reed's facial reactions during the trial. The juror was removed that day. Number 2, Massachusetts State Police interference with the jury factual background. This is what was submitted to the court, babes, with the motion to dismiss paperwork from the defense. TB highlighted Juror A stated that Juror B had made comments to her about the defendant's facial expressions during the trial. We knew this. She didn't like that Karen looked back at her family, or that she, that the other juror just didn't like that. A member of Massachusetts State Police had contracted the court security, and he had received information that a juror thought to be Juror A was at one of the local posts for the American Legion talking about the case, and there may be a recording of her doing so. To which I said, what? To which I clutched my pearls and clenched my butthole thinking about that in the Commonwealth of Massachusetts, we are a two-party state, a two-party consent, okay? No one's clenching my butthole without my consent. No one's recording me without my consent, okay? So that's a little bit fucked if you ask me, that Mass State Police is just willy-nilly saying there may be a recording of her doing this, because I'm pretty sure Juror A wasn't like, let me talk shit at the American Legion and let me waste 9 weeks of my life because I can't be a deliberating juror. You're an asshole. So then a number of officers, at roll call for the Dedham Police on the morning of June 25th, 2024, a number of officers confirmed that they heard a similar thing about the juror. Now, babes, that has never made sense to me. Who, like an owl, is at roll call saying that you all heard a rumor that this random juror was at the American Legion a month before? And why did none of you report it? And how did you confirm it? Because it was never discussed. Other than asking the juror, at which time the juror said, no, I didn't do that. And then when Judge Cannone ended up pressing her and pushing her, she got a little like a little shaky with it. And she said, well, I don't remember. I don't know. I don't think I did that. You're accusing her of talking about a case at a bar room, one of which you couldn't even tell because, let's be clear, they said Knights of Columbus or American Legion, but I digress. The defense said specifically the American Legion. So, so then the court called a sidebar to discuss the new information with the attorneys. The defense counsel asked for the name of the Massachusetts State Police officer who had received said complaint, and the court officer stated that it was Lieutenant Fanning. And where do we know him from, babes? That would be the Sandra Birchmore case, in which he asked Matthew Farwell, did you have anything to do with this? Matthew Farwell says no. And he goes, Daps, bro. Yeah, I knew you didn't. It's not weird that you're, in the camera going in her apartment and then, then you're leaving in a real hurry during a snowstorm, and then you go right to the Newton Wellesley Hospital and your wife has a baby, and her phone never moved and she never spoke to anybody after you left the building, but you said you didn't do it. And you wonder why we think that the thin blue line has become a tall blue wall. Fuck you. Not you, I love you, but you know what I'm saying. All right, so Fanning is a supervisor at the Norfolk County Detective Unit. During the investigation into O'Keefe's death, he was Proctor's supervisor. He was also one of the recipients of a group text circulating by Proctor that included the reference looking for nudes on the defendant's cell phone. After explaining to the attorney the court called Juror A to sidebar, and the following exchange occurred. Oh, babes, I should have known I didn't have to do this. Okay, so who did Michael Proctor's boss, good friend, and fellow corrupt cop, John Fanning, receive information from about this juror? How did Auntie Bev know what the topic of discussion was at the Dedham Police Department that day, and who was reporting on their behalf? And where was this illegally recorded conversation? During the sidebar, Juror A didn't do herself any favors, but also didn't admit that anything she had just been accused of was true. The juror who I interviewed told me that she had no idea that she was recorded and still hadn't heard any tape of it. When asked about the recording, she simply said, I don't know, because she was last at the American Legion over a month ago and couldn't remember what they were talking about. So I just talked to you about this because I'm annoying and didn't read the article. Pardon me. But it says, the court, it has been brought to my attention that you might have been out recently at the American Legion or Knights of Columbus. Oh, it's the elephant brain of a woman in STEM. Just saying. What did I say? I said that. And or someplace like that in Dedham, and that someone has reported that you may have been recorded talking about this case. That's the information I received. What can you tell me about that? And the juror goes, I don't know. And then the court says, have you been at the American Legion Hall? And the juror goes, like a month ago. And then Judge Bev says, okay, at that time, were you talking about? The juror goes, no, not that I remember. No, that is a denial, babes. Okay. That's not an I don't know. That is a firm no, not that I remember. No. Do you remember if people there mentioned to you anything about this case? I was drinking. I don't remember. Which, I mean, vibe checks with the area, you know. But also it was a month ago. And then the court says, okay, the further information I have is that this morning several Dedham police officers said they heard the same thing, which I find sus as fuck. I need to suss that out additionally because that's weird. How did you know about that before you had even spoken to the defense? Weird. And why? I don't know why Judge Cannone, because I know she is smart. I know she is. Why didn't you think that that was weird that a bunch of cops are just talking shit in roll call and being like, oh, yeah, I heard that too. Oh, yeah, dude, I heard that too. Yeah. Yeah, want to play grab ass tonight? Like, no, ew. And then the juror goes, okay. And the court says, all right, could it have happened? The juror, I don't know. The court, okay. The juror, I really don't know. So she's calling it like she sees it. And then it says that okay. The juror told me that on her way into court that day, she had received ominous threat from an unidentified male in traffic, telling her to go quietly. What bitch? When she got to court, she was flustered, and felt ambushed after being called in front of Judge Cannone. She felt like she was being put on the spot to remember a night out at the bar over a month ago, and for the first time was told she was illegally wiretapped. At no point did the juror admit to anything, but she was still kicked off the jury on the final day based solely on the unconfirmed secondhand story from someone who was invested in seeing Karen Reed convicted. Good paragraph, Aiden. Okay, and then there is a backstory to this. This is Ty Donahue from Dedham. Ty dollar signs. Ty donut signs. Woo! Brother, what are you doing? I know I'm odd and off-putting, and Jimmy, I'm getting off-putting, okay, babe? Okay, I don't need to do all of that. He was a Dedham police officer until 2008 when he was fired after being arrested for driving drunk and flipping his car over on I-93 in Canton. Ty had a personal relationship with Juror A and admittedly knew Brian Albert. The text messages reveal that after the juror found out she had been chosen to be on the jury, she told Ty Donahue, oh, for the love of Christmas, Juror A. And she said that she hadn't heard any of the witnesses. And she said that she hadn't heard of any of the witnesses before. Ty is friends with a Dedham man named Ron Hathaway. I feel like, do we know a Ken Hathaway, or am I being a wackadoo right now? As Ty's brother is married into Hathaway's family. I love you guys. Okay. I'm being nice. You okay? Looks like Ty Donahue in the house. Just saying. The Rizzler on the roof. TD. Okay. What hotel do you and AJ stay at when he was in town? Ooh, that's yucky. You're in the mud. Are you talking shit to me? Oh. Are you a dink to me or no? Oh, I didn't make the list. Okay, that's cool. Let's see who did. Microdots. Auntie Bev's Sidebar and Grill. Kerry. LaFario, Nan, DM Sullivan, Henry Blue, Joe Flip Ahead, Joey Bag of Donuts, and Dr. Yellow. Yeah, those are good accounts. Okay, I don't really want to put people's like private stuff on, really. Sorry, guys. I just want to get to. Okay. Oh. Oh. Okay. On June 25th, 2024, the juror and Ty Donahue had a falling out over a personal issue that got ugly. Coincidentally, the next day, before closing arguments, Judge Cannone claimed members of Ty Donahue's former employer, Dedham Police Department, and one of the cops who was on Michael Proctor's inappropriate group text messages reported the juror for statements she allegedly made a month ago at a bar. It just so happens that this guy who felt disrespected over a personal issue with the juror happens to have direct ties to all of the McAlberts, and she knew she was a juror. All of the McAlberts who testified sat just feet away from this juror who was making faces that suggested she didn't believe a word they said. This juror was seen making faces in court by Michael Proctor, Yuri Buchanan, Brian Tully, Nick Garino, and Joseph Paul, all whom work with Fanning, who reported her for an incident he didn't witness over a month prior. In October, this same juror received the threatening email from Kevin Linehan, a McAlbert propagandist with a small audience who has been. No, I'm not reading that. The email was not publicly available, which means Plevin got it from someone that knows the juror personally. Based on what he said, he had clearly been speaking with people who knew the juror personally, didn't like her, and were using Plevin to try to dox her. Plevin falsely accused the juror of being a turtle boy plant, not a turtle boy, but a turtle boy plant, despite the fact that her and I had never spoken prior to the trial. And she says she had only seen one turtle boy blog from my 11 years in existence. Oh, and this is, I remember these. These were from Kevin to the juror. You might know of my channel. If you followed me back in the summer of 23, you know my opinions on things has evolved. Okay, so it is a little bit weird though. So Kevin is reaching out to this juror and then she goes, "How did you get my name and contact information?" And he's like, "Blank, as much as I always aim to lay my cards on the table, I also keep a promise. So if anyone gives me something confidentially, I honor that. I hope I didn't alarm you with this message. You have nothing to worry about. I have no intention of outing you. Outing you are doing anything that will make you uncomfortable." Okay. And she writes, "What parts of my story do you believe you know?" And Kevin says, "Oh no, just kidding." And she says, "This message does alarm me. I never give my email address out. What of my story do you believe to know? And what parts?" Oh no, just kidding. That's the same thing. And then Kevin writes, "This is, I have a live show in a few minutes, so let me get back to you with more detail. I know a lot of what happened right before you were dismissed." Oh. Oh, Kev. Oh, Kevin. Oh, Kevin. I know you wanted to get an exclusive for your book or something, pal, but that's really concerning that you would know a lot of what happened right before she was dismissed when the court didn't tell anyone. The defense didn't know shit about anything. So how do you know, Kevin? Ooh, could it be that the Commonwealth has leaks, babe? Like we've said, forever. And then says, "I don't think I want to get into a whole lot of detail, but my objective is to tell what needs to be told and no more in his book. that he is profiting off the death of Officer John O'Keefe, but we're the devils. Remember that, everyone. But some of it needs to be told. We have another trial coming up, and there are questions as to how you got on the jury in the first place, considering the passionate beliefs you seem to hold before being impaneled. Did you tell the complete truth on the jury form? Oh, that is so fucked. I protected your anonymity, blank, and I will continue to protect it. I have shared no identifying information about you, and I will not. But now you have sent my number to Aiden, which he has broadcast on his show. I don't like that either, but I will still protect you. You don't protect anyone, Kevin. You are a bartender. Who are you protecting? What are we talking about? That is weird. Don't tell women you're going to protect them by not doxing them and by threatening them on their private information that you shouldn't have had in the first place. That is stage 5 fucking creep shit. Stop it. Oh. Did you answer the questionnaire honestly? Shut up. I don't even like this. Sorry, guys. This is getting me pissed off. That's very rude to this person who you don't know. This isn't a troll online. You've got this woman's information that she didn't ask you to have, and the jury list was impounded. Impounded. So how did you get that too, Kevin? It is a complete lie that this woman was well aware of the Karen Reed coverage prior to being chosen on the jury, and Ty Donahue is well aware of this. Here's a text message sent from the juror to Ty Donahue after she was chosen to be on the jury, in which she said that she didn't recognize any of the 160 witnesses on the list. They took me back and forth to the side. Took me back and forth from the side of the bench 3 times. The judge and all the lawyers. Brian Albert is a piece of shit. I know him personally. He wasn't on the witness list. No, he wasn't on the list of witnesses. I don't know who that even is. They read all 60 names. I recognize 0. He must be somewhere between your age and my age. He's a Dedham kid. He's a detective for the DA's office. No, he isn't. He's a Boston cop. But okay. Jeff or Brian? Jeff wasn't on the list. No clue who Brian is. I would have recognized it because I know Chrissy. Yeah, her brother. Brian Albert is the Boston cop. Okay. All right, that's a weird thing. But multiple sources have reported that Ty Donahue is also an illegal bookie. Bitch, a bookie? What year is it? 1995? I'm sorry, guys. Lori Marie says, Cheryl with an S. Of course I missed this. And I can already see it's important. It's not Lori Marie. Don't worry. It's just me. Oh, Kevin Albert. Mandy says, I think it's Kelvin Albert. Okay. Multiple sources have reported that Ty Donahue is also an illegal bookie who may or may not have been thrown out of his house by his wife in July after he became upset with the juror. And this post was left about him on the Free Karen Reed Facebook group, which cannot be confirmed. Oh, let's get all the tea. Okay. All right. Seems Emily threw him out of the home that she owns back in July. He wasn't allowed at the hospital when the second kid was born, and there are 0 family pictures of him on her social media. Someone should let this woman know she looks better without the extra 400 pounds of dead weight. Ooh. This guy is a piece of garbage. He will lie and manipulate anyone and everyone to get what he wants. And for some reason, he thinks he's God's gift to the universe. He's known to be a complete drunk, drinking upwards of 24 beers. You're drinking a case a day, my guy. and putting his kids in the car. Oh, Lord. Oh, this is non-confirmed. I'm just reading what it says on the page. The friends and coworkers I spoke to weren't surprised that this fat slob thought he could get away with jury tampering. Sounds like he's a pompous ass who believes he's untouchable by law enforcement and will never have to face any consequences. Needless to say, nobody had anything nice to say about this guy. It seems unlikely to be a coincidence that the day after this guy with indirect ties to the McAlberts had an ugly falling out with a juror whom he had been lying to about a personal matter for months, that Judge Cannone would suddenly get secondhand reports from John Fanning and Dedham police officers about something she allegedly said at a bar over a month prior. Either way, Ty Donahue was upset and wanted to harm this juror by having her thrown off the jury. And in doing so, a clear not guilty juror with a strong personality wasn't allowed to be in the deliberation room. This is jury tampering. That is it, babes. That's the end of the article. Holy guacamole. What do you think? Tell me everything. Absolutely. Holy shit. Whoops. Whoops. What are we doing? I mean, like, definition jury tampering, right? Okay. This is a lot. It is 10:53 on April 17th. It's a Thursday night. We have to process this. I need to actually think about everything that I just read, because I think that there would be a new motion. If I were a betting woman, I would think the defense may have to file something, because I didn't understand how Judge Cannone was able to just dismiss her without proof, without acknowledgement from the juror, without a recording that was illegal and wiretapped, and without speaking to the Dedham officers that were in roll call. Who gave the information to Fanning? It'll never make sense. Oh, Mimi. Hi, Mimi. Can I add PayPal to my link tree? Sure. I don't know what it is, but I love you and thank you. Okay. Listen to me, babes. I have a prayer, if you wouldn't mind to do a prayer with me. Because tomorrow is Good Friday, and then I changed. I was gonna do like Sunday is Easter, so we're going, like, we have like brunch and church and bunnies and all the things to do and family, and that's the most important. So I'm either gonna do the mock opening on Sunday night late or on Monday. But on Saturday, it's gonna be at least Jimmy and I reading for the part of reader in Commonwealth v. Karen Reid 2.0. Potentially Will the Glairer and also Melanie Little, our attorney and IMDb actress, paid gigs. I mean, she's incredible. But I wanted to, just try to focus us and to say our prayers for those in public office tonight. How interesting that I picked this prayer for Good Friday, and it says for, oh, come on, Kim. It says for public office. You can't read that, whatevs. But it says for all in public office. Let us pray. For those who serve us in public office, that God may guide their minds and hearts, so that all men may live in true peace and freedom. Almighty and eternal God, you know the longings of men's hearts, and you protect their rights. In your goodness, watch over those in authority so that people everywhere may enjoy religious freedom, security, and peace. We ask those through Christ our Lord. Amen. And that is it, babes. I love your faces. More than anything, I thank you for being here with me tonight. You are the smartest, you are the prettiest, and I'll be back. We'll be back. Baby Jesus, we'll be back too. Okay? Going to be hanging out, taking a little siesta in a cave. 3 days, trace. And then he shall come back for us all. Okay? I love you. Be good. Mwah. Night, guys.